This is a short talk on what a protected disclosure is, which was first delivered to the IWGB. Before you're going to be able to get protection against whistleblowing, either for dismissal or for having experienced a detriment, you need to have made what's called in law a qualifying disclosure. And this means you must identify information which you disclosed, and it's got to relate to one of the 6 types of relevant failure that are listed in the Act, and I'm going to come to those in a minute. This is the wrongdoing that you're disclosing. Next, you'll only get protection if you have a reasonable belief that the information tends to show one of those relevant failures, and that means somebody's going to scrutinise your belief and work out whether they consider it to be reasonable, and ultimately that will be an employment tribunal. Next, you've got to have a reasonable belief that the disclosure is in the public interest, unless it was made before the 25th of June 2013, but I'm going to concentrate on disclosures that are made after that time. So I said that information needs to be disclosed. A disclosure can be verbal or written. In fact, it can be in any form. There needs to be transmission of information to a recipient. It's got to be clear from the context that it's not just a very general allegation. So when you're making a disclosure and intending to make a disclosure, tie it into specifics. For example, just saying you're not complying with health and safety requirements without any context, either the physical context in which you say it or other context in your document, is not likely to be regarded as a disclosure of information. On the other hand, if you're standing on a ward in a hospital and you say, I noticed sharps lying around, and then go on to say you're not complying with health and safety requirements, well, that will be a disclosure of information for these purposes. You can make several communications and put them all together in order to say, well, I have made a disclosure. So some of your disclosures could contextualize the other ones for these purposes. But there's a very important distinction between acts and disclosures of information. So you don't disclose information when you're obtaining evidence. So for example, if you decide you're going to make a secret recording or video of somebody and you're punished for that, then that is not going to be a disclosure. It's obtaining evidence. Disclosing the information that you've obtained might constitute a disclosure, but you have to watch out, because if you're punished for having made the secret video, that won't be punishment for a protected disclosure, but it'll be punishment for the alleged misconduct obtained in obtaining the evidence. Finally, there's a gap in the law that if you're sacked for preparing to make a disclosure, you may well not be protected, although there is one employment tribunal case which has referred to your human rights under Article 10 of the European Convention on Human Rights in this respect, so as to give protection. But you need to watch out for a situation where you're being punished because your employer thinks you're likely to make a disclosure. I said that you have to make a disclosure about certain categories of things. So a qualifying disclosure is going to be a disclosure of information which, in your reasonable opinion or belief, tends to show that one or more of the following is happening. So criminal offences, breaches of any legal obligation, including non-UK law, miscarriages of justice, danger to the health and safety of any individual, not just an employee, it could be anybody, damage to the environment, and deliberate concealment of information about any of those things I've just mentioned. So the criminal offence or breach of legal obligation might be past, or it might be one that you say is about to happen, prospective, or it simply could be something that you're alleging is going on. It could be the employer's behaviour or somebody else's, and the misconduct can occur anywhere. You have to have a reasonable belief. This means that you don't have to be right that there is misconduct taking place. You've obviously got to believe that it's taking place, and objectively, that belief has got to be reasonable. So that means, for one thing, it must be more than unsubstantiated rumours. If the disclosure was after the 25th of June 2013, you must reasonably believe that the disclosure is in the public interest. Now, the test on this includes, but isn't limited to, factors like the number of people who were affected by what was going on, what the nature of the interests that they have which were affected, the nature of the wrongdoing, and also the identity of the wrongdoer can be a factor as well. The disclosure has to be made to one of a number of different people, and there are different protections attaching to each category. The principal one is disclosure to your employer, but you can also make disclosure to a person who's responsible for the relevant failure, even if they're not your employer. You can make disclosure to legal advisors, government ministers. There's also a list of prescribed persons contained in an order made by the Secretary of State. Now, these are things like regulators and so forth. So if you're thinking of disclosing to a regulator, it's worth checking on the government legislation website as to whether they constitute a prescribed person or not. You can make disclosure outside those categories if certain conditions are met. And these conditions are varied in the case of exceptionally serious misconduct. So the first condition is that you believe that the misconduct's taking place. Secondly, it shouldn't be done for gain. Thirdly, you should have attempted previous disclosure to your employer or a prescribed person. Next, you should have a reasonable belief that you'll be subjected to detriment or that there'll be concealment or destruction of information or evidence. And it has to be reasonable to disclose in the way you do in the circumstances. Now, in the case of exceptionally serious misconduct, you have to have a reasonable belief in the substantial truth. That's the truth of the substance of what you're saying. Secondly, it mustn't be done for gain. Thirdly, it needs to be reasonable to disclose it, particularly to the recipient that you choose. But there's no need for you to have already made a disclosure internally or to a prescribed person. And you don't have to be concerned about being subjected to a detriment. There's no requirement for you to have a reasonable belief that you'll be subjected to detriment. So this means if you want to go directly to the media, it may be quite difficult to justify if you haven't already made disclosures. But in the case of an exceptionally serious piece of misconduct, you may be able to get protection even if you've gone directly to the media. There are exceptions in relation to information that's given in a legally privileged situation. So a lawyer who discloses something they're told by a client in order for that client to get or give instructions won't be protected if they then disclose that information. Secondly, if disclosure itself is a crime, for example, breach of the Official Secrets Act, then there won't be protection for that. Lastly, there is an exception made for parliamentary staff and for members of the armed forces. And the final thing I want to mention are gagging clauses. There's a provision in the Employment Rights Act 1996, section 43J, which renders a contractual term void insofar as it purports to preclude a person from making a protected disclosure. So duties of confidentiality, for example, will not preclude a person from making a protective disclosure. But remember what I said about the circumstances of going outside your organisation and not to a prescribed body or the person who is responsible for the relevant failure. Thanks very much.